Okay, anything we need to do before we bring the jury in the court?
Oh, yes, sir. We do. I have been tendered audio recordings, at least 2 of them, Your Honor, in the last 2 days. One of them had Miss Amanda Dillon and Detective Jeff Rogers sitting in on an interview with a witness prior to Twin Peaks, Your Honor, that contains information that is exculpatory and that seriously undermines the state's theory of prosecution.
First of all,
Excuse me.
I'm going to object.
May I finish?
No, I'm going to object to the statement right there. These interviews happened after the Twin Peaks shooting. Any assertion of otherwise would just be a flat lie.
Well,
May I finish? I'm sorry. Make the record, Judge.
you may make a record.
Thank you. There are 2 interviews with this particular individual, one prior to Twin Peaks and one after Twin Peaks.
Judge, I'm going to object. That's a misstatement of the facts.
We can play them in open court. But the point, Your Honor, is that this district attorney's office, including Mr. Jarrett and Ms. Dillon and Mr. Reyna, are sitting in a room where witnesses 2 years ago, 2.5 years ago, are making exculpatory statements. And they say that they don't have possession of the recording, but that they had actual knowledge of the contents of the recording. And I'm happy to recite page and verse, Your Honor, of the witnesses and the statements that they've made that frankly should have prevented the state from sponsoring the testimony of all 3 of their quote-unquote experts and would have materially changed my cross-examination of every witness that has testified, save for the first young woman who was a waitress at Twin Peaks. No, she was a cook at Twin Peaks. I mean, I don't know how this isn't Brady, and it is certainly willful. And that fine line of saying, well, we didn't have the recording, you were there. They were physically present in the room when those statements were made. I've made written requests for a statement that was just tendered to me today.
Judge, I'm going to object to counsel testifying. If there's a legal objection she'd like to make, then we can do that.
I'll take the stand. These are absolute facts, Your Honor, that have prejudiced Jake Carzal's right to a fair trial.
Well,
Judge, the facts, if I could state something real quick, the facts are that there is a co-defendant of Mr. Carzal who voluntarily came and spoke with the district attorney's office with his attorney present. The fact that somebody, a co-defendant, came in and lied to the district attorney's office is not an unusual thing. This information that he lied about then is the same information he's lied about before. No, we didn't sponsor this witness's testimony. We don't intend to call him as a witness. So, to make these assertions is just plain false. The state's ready to proceed at this time.
Your Honor, I would just direct the court's attention to ex parte David Mark Temple. It is not within the province of the district attorney's authority to determine whether or not a statement is credible or false. Ms. Sigler tried that. If it is contrary to the state's theory of prosecution, and let's face it, this has been a circumstantial case at best, they are duty bound to give that information to the defense. They don't get to just say that it's false.
Again, I'd object to that. The state's theory of this case is not based on a witness statement from a gang member. The state's theory of this case is testimony by your client on his text messages to other gang members, on his actions that are videotaped in Waco, Texas on May 17, 2015, on his actions before, during, and after the crime. The fact that he's continued to be a bandito, the fact that he's ascended to the rank of president after the crime, the evidence is very clear in this case, and it has nothing to do with the statement of a Cossack, one of his co-defendants.
Your Honor, how many times has a state-sponsored testimony that the conflict at Twin Peaks was about a Texas bottom rocker? 3 separate times. And you can say it's a co-defendant, it's a Cossack. This man was a Cossack, and he's saying that there was no conflict over the Texas rocker. What effect does that have on the state's theory all the way up until now? Because we heard so much testimony about that Texas bottom rocker, and they've got evidence of a Cossack saying, and even a non-club member saying that he was present at their patch party, and there was no beef over any Texas bottom rocker. That is wholly inconsistent with the state's theory of prosecution.
And Judge, the information that Ms. Gautreaux received this morning is confirmation from confidential informants that are very well connected to a certain organization that this was over a Texas bottom rocker. To say otherwise is just untrue.
So in addition to the allegation under Brady and Maryland, Brady v. Maryland, Kyles v. Whitley, it's 3.09D. The prosecution must turn over evidence that is exculpatory, that is inconsistent with their theory, irrespective of their assessment of the credibility of it, Your Honor. I'd like the court, I'd like to know how long they had it and why they didn't give it to us. I have a stack of subpoenas trying to get this stuff, Judge. and then suddenly it appears at this last hour? You were in the room.
Okay. What relief are you asking the court for?
I would like the court to dismiss the charges for prosecutorial misconduct, for willfully hiding and sitting on information that completely guts their case, Judge. I've outlined all three of those men's statements. I mean, I don't see how there's anything fair about this. They were in the room. You were there.
Actually, Ms. Gotro, if you want to listen to that tape again, Mr. Rand and I left the room shortly after he started because he's such a liar.
Miss Dillon was there the whole
You just
time.
said I was.
You started there. Well, you didn't announce your presence or your exit.
Okay.
But you knew.
All right.
I knew a liar was in a room. You're correct about
He's
that.
lying because it's inconsistent with your theory.
Yes. My theory is your client committed a crime. He text messaged before and
I have
after
a
the
theory
crime.
about his committing crimes.
Okay. Let's address the court. Let's not be arguing between the attorneys. Then the defense's motion to dismiss is denied at this time. Anything else we need to take up before we bring the jury in the court?
Your Honor, at this point, if my motion to dismiss for prosecutorial misconduct and the willful hiding of exculpatory evidence is denied, I need a continuance so I can read the information that I've just gotten this morning. I don't even know what's in this report, Judge.
Then we'll take a 45-minute recess at this time.
It's criminal. It's criminal and it's unethical. It's criminal. This really works.